Okay, we are back. Counsel who watched the first argument, you know what you're in for, right? Any preliminary matters before we get started?
No, Your Honor.
All right, Mr. Hibner, you may call the case.
Annie J. Jones, fighting through her conservator Joyce Sons, also known as Calisa Joyce Sons, versus Life Care Centers of America, doing business as Life Care Center of Tullahoma.
Good morning. I'm Alan Bean of the Nashville Bar. I practice with Starnes Davis Flory, and I represent Life Care Centers of America, Inc., doing business as Life Care Center of Tullahoma in this matter. We thank you for the opportunity to present these arguments today in what I think everybody here would agree is a very, very interesting case from a factual standpoint, very unusual case, but a very important case nonetheless. And the first thing that we're asking this court to do is to first reverse the Court of Appeals conclusion that in Tennessee, in a claim for invasion of privacy for the intrusion upon seclusion of another survives the death of the person whose privacy rights were violated. This court, in 2001 in West versus Media Convergence, Inc., expressly adopted the Restatement Second, Section 652, and specifically adopted 652I, which pertains...
Let me you there for a moment and just ask, so when the court adopted that section in West, is it your position that the court adopted it in its entirety or only with respect to the false light claims that were at issue there?
It's our position that the court adopted 652I in the entirety. I acknowledge that in West it dealt with a false light claim, and this court in West specifically analyzed false light and applied 652 and all its provisions, including 652I, to false light. But the language from West does not limit the adoption of 652I to only false light. In fact, the court acknowledges 652 and the comments A through C, and it does so in a general sense. And it describes 652 as being adopted in the context of invasion of privacy claims in Tennessee, not just for false light. Invasion of privacy involves 4 different types, and the only type of invasion of privacy that is taken out of the context of 652I and therefore survives the death of the person whose rights were violated is appropriation. And it's stated in 652 that that's the only exception. So our position is that this court in West, and that was echoed, by the way, we submit in the Harris versus Horton case by the Court of Appeals, which was an intrusion upon seclusion case, that 652I does apply to any type of invasion of privacy claim except for one that involves appropriation.
Well, counsel, I have consulted the author in that Harris case, and you may be overstating a little bit. Let me just say at the outset that the court directed you to be prepared to address whether issues were waived. I'd like you to, obviously, you have launched into the main issue, which is appropriate, but I do want you to address briefly whether the other issues that you raised are waived.
Your Honor, thank you. And it certainly was not our intention or my client's intention to waive any of those other issues. I acknowledge that the other issues, in particular, whether, and really it's only an issue I think that we get to if the first issue is not resolved in our favor. But the second issue was not included in our application. I concede that. I acknowledge the case law that was referenced in the order that was submitted, and I read that. It's our position, though, that if you read Tennessee Rule of Appellate Procedure 13A and B together in context here, that this court certainly has the discretion to take up those additional issues, additional questions of law. We would ask that you consider doing that. I would note for the record that obviously we've fully briefed those other issues, despite those not being expressly listed in the Rule 11 application. Appellee has likewise briefed those other issues. I'm certainly prepared to address them today, and I'm sure that Ms. Martin is as well. And we would ask that in the interest of judicial economy, the fact that we're here, we've done the work to get here, that this court consider those other issues as well.
Okay. All right. Thank you.
Thank you.
Let's do this. As you mentioned, those issues are fully briefed. We have your briefs. We've read them. Why don't you use your time in oral argument to address the main issue as you have started.
Very good. Thank you. So we submit that in West, this court adopted 652I and concluded, based on the restatement, that a claim for invasion of privacy under intrusion upon seclusion does not survive the death of the person whose rights were violated. I referenced Harris versus Horton. The difference in Harris was that the privacy right in that case did not involve the person necessarily was included on the photographs. The family asserted their own privacy right as a result of the incident. And so that's clearly different than the case we have here. There's no dispute that the privacy right that's being asserted belonged to Annie Jones, and that Annie Jones is now deceased. And so we're left back with the West decision and with 652I and the other portions of the restatement.
Mr. Bean, so here, let me explain the problem I'm having with your argument. This is a situation where we have a statute, the survival statute, right, section 25102, that's been on the books for a long time. So this statute predates by many years this court's purported adoption in West of section 652A. So if let's assume that that you're right, that the court adopted that in its entirety. I mean, I look at section 25102 and the language there seems very clear that all civil causes of action survive, except for the ones that are expressly accepted, and this doesn't fall into that category, or at least you can argue otherwise if that's your position. So we have a pretty clear statute that has been on the books. What authority would we have as a court to adopt through our common law decision making a principle of law that conflicts with a statute?
So I, first of all, respectfully disagree that 20-5-102 is clear. As you noted, it says all wrongs, but then it has that except for wrongs affecting the character. And that, I submit, is a very vague term. We have looked, my team has tried to research far and wide to find what they're actually talking about. What are the bounds of that character idea? There are certain causes of action which I think make sense that would be included in it, but character is not a specific cause of action, and so I'll admit I don't even know what would be included within character.
Well, let's assume that that section 25102 would allow this cause of action to survive. So let's assume that, and then let's assume that adopting the restatement, that your position about what the restatement says is right, and that under the restatement this claim would not survive. What authority do we have as a common law court to adopt through common law decision making a rule that conflicts with a statute?
Well,
that was already on the books.
You've really painted me into a corner there by asking.
There's a lot of assumptions there. I've realized that.
There were.
I kind of suspect that was on purpose.
I think it was too, and that's okay. But so I think if you're making me assume that 20-5-102 absolutely applies to a cause of action for invasion of privacy, for intrusion upon seclusion, then looking back at the restatement second, 652I, if you're making me assume that, there's not an absence of statute, and you're asking me to assume that is the 20-5-102, despite saying except for character, that is a particular statute, using the way that we all understand the word particular to be, then if there is a conflict, then usually the statute wins and prevails. I acknowledge that.
So you would agree with that if so to rule in your favor, let me just make sure I'm getting this right. So to rule in your favor, we would have to hold either that the statute doesn't apply, or that, well, I mean, I guess we would sort of have to hold that, right? That the statute just doesn't apply, because even if we say that it's not the sort of particular statute that the restatement provision contemplates, that would still kind of put the restatement provision above the statute.
I think there are two routes. One, you just identified, that if you interpret that the statute, that there is actually an absence of statute. So if we look at the restatement, as it says, 652I applies unless there is a statute. In the absence of statute, 652 applies. So number one route to us winning the case would be there is an absence of statute, and certainly that's what we contend here. Because 25102 is so vague, doesn't expressly or specifically list invasion of privacy or even describe a cause of action other than character. That's one route. The second route would be if, in defining what character means.
Well, Counsel, now that you mentioned that, define character for me. How would you define it?
I wish I could, in the context of an intrusion upon seclusion claim. I think that character, I mean, I'll tell you this, Justice Page. The interesting thing to me about this discussion is the common traits among character and the types of damages you might have for character in a defamation action, for example, and the types of damages that we might think about with an intrusion upon seclusion claim. As the restatement second notes, the right to privacy is such a personal, peculiar cause of action and personal trait, just like in defamation.
Well, let's put that aside. What are some causes of action you think clearly would impact character? You mentioned defamation. What are some others?
Defamation, I think Ms. Martin may disagree with me, but I think that her brief suggests that false light, invasion of privacy for being in false light, might invoke character. Beyond that, I don't know, and in going back to the 1967 statute and trying to address and define that, that's where I've really struggled. I think that's another reason why when we compare 20-5102 to the other states that we've cited in our brief, Arkansas, Kansas, Kentucky, all of those are actually more specific than 25102. They don't say character, they say defamation, libel, slander, malicious prosecution.
But we have the word character in our statute, so that's what we have to deal with. And you determine whether a term is ambiguous by the context in which it is used, right? So in some factual situations, you know, there might be a gray area where you're not sure, does this involve character, does it not involve character? But is there any definition of it that would include an intrusion upon dignity like this one?
Again, I think that if you think about the different types of damages that might be available for one, a defamation case, and then here an intrusion upon seclusion, we're really talking about the effect that it has on someone internally. What does it mean to their self-worth?
Is there a definition of character that encompasses, that's my question. I'm not,
That seems almost like an answer to what the damages issue, not the definition of character.
yeah.
I mean, I will say this, Your Honors. The fact that we're having to have such a strained debate about what character means, I would submit to you underscores my point.
I'm positing to you, it does not seem strained to me to say that this does not involve character. So I'm inviting you to show me how it actually does.
I don't think we're necessarily disagreeing with you that character in some instances may be ambiguous, but is it really ambiguous in this context of this factual setting?
I think it's not only ambiguous, but here we have an additional fact. It's not just whether it's ambiguous. The restatement second is very clear in saying that it has to be a particular statute. And that's I think,
in the restatement.
That is in the restatement.
That's not in governing statutory law. That's in the restatement provision that we, you know, your position is we have adopted that, but you've acknowledged that we can't adopt a common law rule that conflicts.
You can't, but I think, and this is a little bit circular, and I apologize for doing that, but it's the fact that we don't have a particular statute, in my opinion, then leads back to the fact that there is an absence of statute, therefore there is no conflict. There is only common law in Tennessee, and there is only the restatement in Tennessee. And 25102 did not address that, does not address it, is not in conflict, and I would note that the law was passed in 1967. The restatement second was published in 1977. This court arguably adopted 652I for all invasion of privacy, but certainly for false light in 2001, and yet our legislature has never amended 20-5-102 to try to address that issue specifically.
Let me ask you this. So I'm looking at 25102. It says, so I'm going to give you another assumption. I'm sorry.
That's okay.
Let's assume that this is not an action for a wrong affecting the character of the plaintiff. So this doesn't fall into the exception. So what the statute says is that no civil action commenced, whether founded on wrongs or contracts, shall abate by the death of either party, but may be revived. Is there any argument that this action would not fall into the plain language of that statute?
Again, I struggle with what character means.
Look, we're
But-
setting that aside, so
Okay.
forget about that.
So take that out. So is
Yeah.
this a civil action commenced, and is it founded on a wrong or a contract? Yes, it is. So,
So you are, I mean, what you are doing then is asking us to disregard the plain language of the statute in favor of a comment to a restatement provision that requires the legislature purportedly requires the legislature to speak with particularity.
well,
That is asking us to kind of elevate a new common law rule above a pre-existing statute.
I would respectfully disagree. I'm asking you to interpret this statute and to interpret whether this statute is particular and whether it's particular enough to overcome the presumption
But
in
the only thing
652.
that requires it to be particular is the restatement provision.
Right, which was adopted by this court. So
When this statute was already on the books.
correct. And then as I pointed out earlier, the statute has not been amended, and presumably there would have been, I mean, when this court referenced the statute, referenced the restatement specifically in West, and this is something else that I haven't really covered specifically. I find it amazing that in 2001, a certified question was presented to this court under Rule 23, and that the Supreme Court of Tennessee analyzed this issue to answer this very important question of, do we even have, under Tennessee state law, a common law right to invasion of privacy for false light? Thoroughly analyzed it, did a survey of the majority jurisdictional view and the minority view, defined the bounds of invasion of privacy for false light, including a discussion of the restatement, including express reference to comments A through C of 652I, which acknowledge that in the absence of statute, it will not survive, and yet did not address 20-5-102. And I submit to you the reason why is this court looked at the statute and said it doesn't apply. There's an absence of statute. There's an absence of statute, and it's certainly not a particular statute, and therefore 652I is the common law, and there is no statute that addresses it. Therefore, there is no conflict.
Well, I'm trying to frame how we approach the analysis in this case. Let's put the restatement aside and just assume there might even be a question about whether Tennessee would recognize an intrusion upon seclusion claim. Let's just put the restatement aside. Doesn't this start and end really with interpretation of the statute 25102?
If we put the restatement aside, then there are some Tennessee cases prior to the restatement that would address invasion of privacy. But yeah, if we put the statute aside, or if we put the restatement aside, then we're really just looking at the statute. So it takes me back to and maybe this is what you're again asking, is what would be included within wrongs affecting the character of the plaintiff?
I'm trying to figure out, in terms of interpreting this statute, which I think has to be the first step, what language are you asking us to interpret that favors your reading? What particular text are you asking?
I'm asking whether actions for wrongs affecting the character of the plaintiff is a particular exception without expressly saying that invasion of privacy is included within that. Whether that's an exception to the restatement second, which is essentially
Well, I mean, the first question has to be, does this claim, intrusion upon seclusion, fit within the exception in the statute? It's an express exception in the statute. So are you asking us to hold that this claim involves the character?
I think that, I mean, obviously, I think I've made my primary argument clear. As a secondary argument, I think that you can read into character this notion of intrusion upon seclusion. And it frankly goes back to this case being so unusual. I mean, if I tried to craft a law school fact pattern final exam question on privacy, I don't think I could come up with one any better than this case. And so I think there are absolutely intrusion upon seclusion situations where someone might say it affects my character. If someone here, because they're so, intrusion upon seclusion is so almost interwoven, frankly, with defamation, libel. It can blend over into that very easily. If something happens to someone, their seclusion is intruded, and then it becomes publicized. That's now embarrassing to me.
Does it blend over in this situation so that it involves character? Because we have to we have to look at it in light of the facts.
You do, and I'm sort of now jumping into some of our secondary arguments on the other issues. But the single fact in this case that makes me answer your question no for this specific case is that it is undisputed that this resident of the nursing home was never aware that the intrusion ever even occurred. And so that's it's the classic example of trying to take this unbelievably unusual fact pattern and then try to craft a rule out of that we need to interpret the definition of character of the plaintiff. And I do think, if you look in the restatements, if you look in some of the other...
I want to make sure I understand your answer. Are you saying that under the unusual facts in this case, it does or does not involve character?
I don't think that it involves character because I don't think it was even an intrusion upon seclusion because she wasn't aware that it ever happened.
Okay, thank you.
But going back to the definition of character of the plaintiff, I think that you can clearly see and think about some situations where it might involve the character of the plaintiff if a person is aware that their intrusion or that the seclusion did occur.
Well, you could change the content of the video, right? I mean, you change the content of the video to, having, the video recording some conduct that would bear negatively on the character
Correct.
of the plaintiff. But that's not this case. I think you
Right.
acknowledge that.
Right.
And I don't see anything in the text of 25-102 that would require us to draw some sort of categorical line and say, well, all of these, this kind of action, categorically is a wrong affecting character.
I agree.
We could sort of do it on a case-by-case analysis. Do you agree with that?
I agree, and again, I know I'm not sure. I'm not sure if I've been let out of the corner that I was painted in earlier. I think I have, so I'm going to assume that I have. But it again takes me back to the particular requirement for the statute. If there were a statute, for example, that said, except actions for wrongs for invasion of privacy affecting the character, that might be a situation where we would have truly a conflict. But it just says character. So I will sort of pivot with the time that I have left here in the initial part of the argument to some of the secondary points just briefly. And that
Before
is,
you pivot, Mr.
Yes,
Bean, I
yes.
just want to make sure that I
Sure.
understand. You agree that 25-102 applies to this case?
I do not agree that it applies to this case.
And why doesn't, I thought you said,
No, our position is that there is an absence of statute in Tennessee that would address intrusion upon seclusion and whether it survives. Because we submit, just like the courts in Arkansas, Kansas, and Kentucky concluded, that 20-5-102 is not particular enough to address that exception. And so therefore, there is an absence of statute, and therefore 652I, common law, is all that we're left with. And a great example, by the way, of a particular statute is found in Wisconsin, which we cited in our brief. It expressly states, the Wisconsin statute expressly states, the following causes of action shall survive, and one of the examples is invasion of privacy. That is a particular statute, and that is one that overcomes the presumption, the general rule in 652I, not this sort of vague statute. And I would add that if you compare ours to the statutes in Arkansas, Kansas, and Kentucky, and in all of those states, the courts there determined that their statutes were not particular, and they found that invasion of privacy does not survive.
But those were
All right,
different statutes. Go ahead, sorry.
Let me just make sure, because I thought Justice Campbell read the statute to you, and you said that it applied,
Well,
but,
she read it without the middle part of the except for the character of
But
the.
you just also said that this is not an action affecting the character of the
This,
plaintiff.
this particular case, I don't think you
Right.
can say affects
So
character.
we can set that aside. And should I let me re-ask the question.
Back in the box.
I don't think I ever left.
I think this feels like a penalty box.
That's okay.
All right, so let's go back to the statute. So is this, let me find the exact language again. Is this a civil action commenced that is founded on a wrong or a contract?
It is.
Okay.
all right, but it doesn't apply in this case?
Not in this specific case. I don't think so.
Why?
Well, number one, there's no proof that there was ever any awareness that this intrusion actually happened. And so there's no,
So it's
We
okay,
can't-
it's okay, what you're saying is it's okay to take nude videos of elderly women as long as they don't know about it?
I'm absolutely not saying that. And obviously, I don't think that this court would be saying that if you rule in our favor here.
But
It's-
isn't that the consequence of what you're asking us to do in that situation? I mean, isn't it the same if you have an infant and you're taking pictures? The infant's not going to realize what's going on with that.
I don't think so, because there would be any number of other causes of action that you could bring to try to pursue that. That comes back to how unusual this fact pattern is, with no evidence of pain and suffering, no physical injury, no mental injury, no economic damages, and no individual claim brought by anyone else. It's a truly unusual and I think probably unprecedented fact pattern. And I see I'm out of time.
Thank you,
Thank
counsel.
you.
Chief Justice, may I proceed?
You may.
Good morning, Your Honors. My name is Sarah Martin. I represent the estate of Annie Jones in this case. As Your Honors have noted, this case involves an elderly nursing home resident, a vulnerable resident who had significant cognitive impairment and could not appreciate what happened to her. The act of this employee videotaping her nude and transmitting that to her incarcerated boyfriend violated Ms. Jones' protected interests in privacy and dignity. And the state, in its investigation of this incident, characterized that as abuse, and the facility has never appealed or disputed that determination. The trial court dismissed the case because it determined that Ms. Jones lacked any proof of actual damages. The Court of Appeals reversed, of course, finding that the plaintiff stated a claim for a cause of action for intrusion upon seclusion, and that cause of action does not require proof of actual damages. This court should affirm the Court of Appeals decision for two reasons. First, Tennessee's survival statute is intentionally broad, allowing all civil claims except for those affecting the characters to survive the victim's death. And second, because the Healthcare Liability Act contemplates any theory of liability, the Act's requirement of injuries should be interpreted broadly to include the violations at issue here. Do Your Honors want me to address the waiver issue first?
No.
Okay.
We have both parties' briefs.
Okay. And I'll just call your attention to the two additional issues that the plaintiff has raised, and we can allow our briefs to stand for those particular issues. But the plaintiff has raised the issue of the common knowledge requirement in healthcare liability actions in terms of whether she even needs expert proof to prove this type of damage, and also whether alternatively that definition of injuries should encompass this type of cause of action.
Ms. Martin, let me ask you this. if we decide in your favor with respect to 20-5-102, this claim survives, do we need to do anything other than that in our opinion? Do we, other than affirm the Court of Appeals and everything else?
I don't think so, Your Honor, because that would necessarily mean that the plaintiff can go back and amend her complaint to more specifically assert the cause of action for privacy violation. And so I don't think the court would need to do anything else. I want to kind of talk about the timeline of this, because the defendant's position appears to be that because the statute is so old, and then the restatement kind of came later, that the Tennessee legislature should have gone back and amended the survival statute. I think that is backwards. So as you pointed out, only wrongs affecting the character of the plaintiff shall abate by the death of either party. At common law, the general rule was no claim survived a person's death. In 1835, though, the Tennessee legislature enacted the survival statute, which is, again, incredibly broad, exempting only those claims that affect the character. And Your Honors asked about, what does that mean? What else have we decided affects the character? There are several things that courts have over time determined affect the character of the plaintiff. Libel, slander, malicious prosecution, the abolished civil claims for criminal conversation or seduction, which involved adultery, and even federal rule, or excuse me, Tennessee Rule of Evidence 404 has a comment that says, hey, character evidence is okay as long as character is at issue, and cites defamation as an example there. So this court knows what that means. And so it's the plaintiff's position that that statute is not ambiguous at all.
Is a false light claim an action affecting the character of the plaintiff?
I would submit it is. And the reason for that, Your Honor, is because, as discussed in the West case, the false light claim it is sometimes used as a substitute for defamation action because it's so similar. And so sometimes plaintiffs file defamation actions, sometimes they try to plead something like malicious prosecution or false light to kind of get around those First Amendment requirements that make the standard for pleading defamation quite a bit higher because of those First Amendment implications. False light is one of those types of actions that would affect the character because it involves this publicity and involves those reputational type harms. And I would submit to you that if a claim does not involve those sort of reputational type harms, that sort of publicity, it couldn't possibly affect the character of the plaintiff.
So what do you make of, in West, we did say that at least with respect to false light claims, citing the comment and the restatement provision that those do not survive. So if we hold here that this intrusion upon seclusion claim does survive just based on the plain language of the statute, does that require us to abrogate West in any way, or can those two holdings be reconciled?
It does not, and it's because of that character involvement. The other thing about the West case, of course, and why the restatement certainly shouldn't apply to this type of claim, intrusion upon seclusion, is because it wasn't the certified question in West. This court, to the extent it spoke on invasion of privacy more generally, that would have been dicta. It wouldn't have been at issue in that case. It wouldn't have been necessary to this court's determination. What was necessary to the court's determination were the parameters of the false light tort, and that is what this court did when it adopted the restatement. And if you go back to the timeline that I was talking about here, invasion of privacy claims have been around since the late 1800s. I think Justices Brandeis and Warren authored a law review article way back in 1890 for the Harvard Law Review talking about invasion of privacy claims. This court first adopted invasion of privacy as a tort in 1956 in the Langford versus Vanderbilt case, which was about a newspaper essentially publishing court documents. And what that court determined was these are public records, so there couldn't have been an invasion of privacy. But it presumed that an invasion of privacy was a cognizable action in the state of Tennessee. That was reaffirmed in 2000 in the Roberts versus Essex Microtel Associates case that the Court of Appeals reviewed. And so if you look at kind of that gap between the first time Tennessee has a case where it expressly recognizes that invasion of privacy exists, that 1956 case, and then in 1967, the survival statute gets amended, the legislature is presumed to know that, hey, invasion of privacy is now a cause of action, a recognized cause of action in the state of Tennessee. It is then that they could have amended and to accept invasion of privacy claims, and it chose not to. So it's not that the restatement came after that 1967 amendment. It is that the invasion of privacy claim was recognized before the 1967 amendment. And that act of the legislature to not amend it to exclude invasion of privacy claims should be presumed intentional. And also to point out in the West case, another reason it's not applicable here is that there was no survival issue there. There was no plaintiff that had been deceased prior to filing the action or who died during the pendency of the action. So again, that certified question matters. Do the courts of Tennessee recognize the tort of false light invasion of privacy? And if so, what are the parameters of that tort? Not does Tennessee recognize invasion of privacy and what are the parameters, but it specifically dealt with false light. And that decision is consistent with the survival statute because false light affects the character. It is sort of a substitute for defamation claims, and it has that publicity element, and it yields those types of reputational harms that defamation also deals with.
Could you envision a situation where an intrusion on seclusion claim would fall within the exception? I understand your position that this one doesn't, but do we need to have a categorical approach to that question where it's kind of based on the elements of the claim, or could it, be a case-by-case determination?
If it's a case-by-case determination, certainly in this case, there's no character at issue. If the court were to more broadly adopt the position that the survival statute doesn't preclude any invasion upon seclusion claims, I think that would be okay too. And the reason being that once there's like a publicity element, it sort of becomes a different type of claim. There was something raised earlier where what if something embarrassing got out to everybody? Well, that's the publication of embarrassing facts, of private facts. That's not intrusion upon seclusion. Intrusion upon seclusion is specific to someone invading my person or someone invading my privacy as to my affairs. And so I think categorically the court can make that decision as well. But if Your Honor is more inclined to make it a case-by-case decision, then in this case, certainly there would be no character at issue. And this is something that the 1977 restatement does recognize, is that a statute can be an exception. And so if Your Honors were to hold that, we think we did cover this in West, and we do think we adopted the restatement in West, I would submit that Section 652I does conflict with the survival statute, and I'm not sure the court considered that because it wasn't particularly raised at that time. There was no death of a party in that case. And so I think even if you were to say, we think that we covered this in West, we think we definitively decided that the restatement applies to this tort as well, I still think it's compatible with the language of the survival statute, but not to this tort, which was not at issue in West.
So we could just say, so assuming we did adopt the restatement with respect to these kinds of claims, we can just read the in this absence of a statute language and hope that we don't have the absence of a statute here. We have a statute, and that's a way to kind of harmonize the two.
Yes. And so in harmonizing the two, you look at the statute, that came first, the restatement came much later, but the important thing is that that privacy action was recognized prior to the restatement, and that's the timeline that this court should be looking at. The court should be looking at the fact that the privacy tort was recognized and the legislature still did not amend the survival statute.
Well, but that's really reading a lot into the legislature's failure to amend the statute, isn't it? I mean, the legislature had a particular objective in mind when it amended the statute. That's really putting a lot of weight on inaction.
It is, but that's what the canons of statutory interpretation say to do. If a statute is amended and the legislature has the opportunity to do that, they're presumed to know what the law is and presumed to act accordingly. And so while it does seem like a big onus to put on the legislature to know the entire body of law, that's what courts do all the time. The defendant also raised the issue of knowledge and the fact that this is potentially not even an invasion of privacy, intrusion upon seclusion claim at all. On top of that issue not being raised and being waived, if the intrusion upon seclusion claim survives, knowledge of the wrong is not required. Intrusion upon seclusion claims are always evaluated objectively under a reasonable person standard. And so, to Justice Tarwater's point, the policy implications of, and I do need to, my timer is, I have no idea how long I've been talking.
The light
So
does
sorry.
not appear to be working, Mr. Hibner.
I'm not sure why. You still have 16 minutes.
Thank you. If you could just give me a little warning. And so to Justice Tarwater's question, wouldn't that be terrible? Well, yeah, of course it would be terrible. We're literally creating a different standard for nursing home residents who have some cognitive awareness, and then having a different category of people who can be abused with impunity, and there's no civil cause of action for that. That's a terrible public policy effect of this case if it were to be reversed.
Let me follow up on that a bit. So in this situation, your client was not aware of the video. She did not know that her privacy had been invaded. I understand why her claim might be actionable. I understand that argument. But why would it survive then? Okay.
It just goes back to the legislative intent of the statute. Wrongs affecting the character is not ambiguous. It's broad. The statute's incredibly broad, but that clause in the statute is not ambiguous. This court knows what that means. This court knows what actions affect the character. We have jurisprudence on that. We have a rule that states that defamation affects the character. And so in this case, with the knowledge piece, not only is it not required for an invasion of privacy, if you look at the restatement guidance, but deciding the other direction makes this pretty egregious. Because again, we have a state investigation that said this facility failed to report abuse, it failed to prevent abuse, and characterized this entire act as abuse. It cannot be the case that a jury can't determine what that's worth. And general damages or non-economic damages are the appropriate way to deal with that, and we have a statute on that as well. 29-39-101 deals with non-economic damages, which include physical and emotional pain, suffering, inconvenience, physical impairment, disfigurement, mental anguish, emotional distress, loss of society, companionship, and consortium, injury to reputation, humiliation, non-economic effects of disability, including loss of enjoyment of normal activities, benefits, and pleasures of life, loss of mental or physical health, well-being, or bodily functions. And the very last clause, which is important here, it's a catch-all, all other non-pecuniary losses of any kind or nature. Juries have been doing this for a long time. Under the Court of Appeals decision, Miller versus Chu Partners, the court determined, hey, a jury is capable of awarding non-economic damages for non-pecuniary losses. That statute is the reason why they were permitted to do that.
And what is the state of the record on the damages in this case? And is that something that we even need to consider in determining whether the cause of action survives?
In terms of survival, no, and I don't believe it was properly raised for determination in the Rule 11 application. But to Your Honor's point, that is the crux here, was the crux at the trial court. Does the Healthcare Liability Act allow for just general damages when there is no physical or emotional harm? And because of the breadth of the HCLA, it's the plaintiff's position that it does encompass that. So there's a lot of emphasis placed by the defendant on the word damages, but damages is not the word used in the Healthcare Liability Act. The word used is injuries. And injuries is very, very broad, and this court would have to determine what does injuries mean in that context. In the professional malpractice context, under the Cherry versus Williams case, this court defined it as any wrong or damage done to another's person, rights, reputation, or property. And in the constitutional standing context, when we talk about an injury in fact, under the Lujan decision of the Supreme Court, it's an invasion of a legally protected interest. This is a legally protected interest. No one is in disagreement here that the Residents' Rights Act includes rights to privacy and rights to dignity. No one in this case disputes that those violations occurred here and that all nursing home residents have a right to those things, regardless of whether they are cognitively with it enough to appreciate those harms.
Lujan was decided under the United States Constitution.
It was about a constitutional injury for standing. And so the Healthcare Liability Act is extremely broad. When the law of medical malpractice was amended to put this statute into place, when this was enacted in 2011, there used to be a cause of action for ordinary negligence and a cause of action for medical negligence. So what we have now instead is a common knowledge exception, and if it's against a healthcare provider, it's usually healthcare liability.
But that's a justiciability doctrine, correct? That,
Lujan is, yes, Your Honor.
okay.
Yes, Your Honor.
Let me go back to my earlier question here. If we simply rule in your favor and affirm the Court of Appeals, they just said they reversed and sent the case back to the trial court to be handled consistent with the opinion. What else do we need to do here? Do we need to get into the Healthcare Liability Act at all?
No, Your Honor.
Okay.
But that's sort of what the Court of Appeals did, is they took this broad statute that says, regardless of the theory of liability, if this is a cause of action against a healthcare provider for healthcare services, it's a healthcare liability action. And so put simply, under this court's jurisprudence, and specifically the Ellithorpe case, this court's already determined how broad the Healthcare Liability Act. It encompasses every theory of liability against those providers. And so here, the only thing that the court needs to decide is that there's an injury. And so the Court of Appeals couched it in an invasion of privacy claim. They said, what is the gravamen of the complaint? Well, the gravamen of the complaint states a cause of action for invasion of privacy, intrusion upon seclusion. And in that context, the injury is the invasion of that protected interest, that right that's invaded, that is the injury. And so that's what the Court of Appeals did. So affirming that on that basis, that's all this court needs to do. How am I doing, Mr. Hibner? Okay. And
You
so
don't have to use all your time.
I don't. You're right. I do want to touch on the public policy implications here, because I don't think they can be overstated. It cannot be the case that the defendant admits that there was abuse in its facility, but that no compensable wrong occurred. And so even without actual damages, medical bills, severe emotional distress, a jury can determine what is the value of that loss of that right? What is the value of that invasion of that protected interest in dignity and in privacy? And it just simply can't be, as a matter of public policy, that the defendant's position gets adopted, because what happens inevitably is that there's no deterrence for the defendant providing this type of care and preventing these types of acts. There's no impetus there's no deterrence value in this case for the utter disregard of very vulnerable people's rights. And stated another way, the court has to answer, is the loss of this protected right, is that enough for an injury under the Healthcare Liability Act? And if the answer is yes, but only if the victim understands what's going on, we are again creating two different sets of rules for people that have awareness of what's happening to them and people that don't. And so
and just to clarify again, you're not asking us to reach that issue here?
You don't have to, Your Honor. You don't have
Is
to.
it your, so, I guess the outset of your argument, there's a little bit of discussion of waiver, but just to clarify what your position is, I know you didn't argue in your brief that the issues that were raised in appellant's brief but not in the Rule 11 application were waived. Is that still, what is your position now on whether those issues were waived?
The plaintiff didn't raise waiver, and that is my bad. But if the court is asking me, did the defendant waive those issues, I think it's pretty clear that it did.
Okay, and you're not asking us to reach any of those issues other than the one issue on which we granted review? Correct.
But the plaintiff under the case law, I think it was the Hodge case, I'm sorry. Yes, the Hodge case. So one of the things that the Hodge case also said is that because, there's also this rule that dictates what the person responding to the Rule 11 application can put in their answer, and it doesn't actually give the responding party the opportunity to raise any issues in that answer. And so the court has determined that, and this is from Hodge, that a party who has not filed a notice of appeal or Rule 11 application may present additional issues of their own seeking relief. And so that additional issue, if the court says privacy actions don't survive, it can go to that second issue and say, while privacy actions do not survive, we do feel like Miss Jones did have a protected interest in privacy and dignity. We do think that is an injury within the meaning of the Healthcare Liability Act, and we think that a jury can figure out what that is worth, even if it's just $1. And so for those reasons, we did raise that second issue sort of as a fallback position in case this court is inclined to find that the cause of action does not survive. But if the court were to agree with defendant's proposition, again, the effects cannot be understated. The Court of Appeals sort of rightfully contemplated that concern about vulnerable persons. And it said, the present case is a rare one in which Ms. Jones was unaware of the intrusion on her private affairs and, as such, provides no evidence of mental or emotional ramifications. Additionally, it is undisputed that she suffered no actual or economic damages. Even so, we would consider it a detriment to public policy to condone intrusions upon seclusion of the most vulnerable, those unable to comprehend that the intrusion is occurring without the possibility of redress or consequence. If this court were to disagree with that proposition, you can imagine the case that comes next. It's the case where a nursing home leaves a demented resident in their own filth, but the resident doesn't get an infection, or the nursing home allows a person to fall and the person isn't injured from that fall, but they're left on the floor for several hours. Or what about a demented person who is coerced into sex or forcibly raped but doesn't have any memory of it and doesn't show any symptoms of emotional distress? Those are the cases that come down the pike that will not be litigated at all if this court's decision, if this court decides to overturn the Court of Appeals decision. And so it's for those reasons that we would ask the court to affirm, as long as there's no other questions.
Thank you, counsel.
Thank you.
How much time was reserved for?
4 minutes, Your Honor.
Sometimes in a case like this, as interesting as this, you can read these briefs 100 times, you can read the cases 100 times, you can think about the issues over and over and over again, and you don't have sort of a sudden new view on things until very late in the process. And I'll admit, I had one of those thoughts during counsel's presentation, and it has to do with whether the facts of this case are actually at least, I don't know about more akin, but certainly blend over into a publicity of private facts. If you think about it, what we have here is a situation where Ms. Jones is being showered. It's not just that someone intruded her seclusion, it's that someone, by way of a phone call, essentially published that information to a stranger. So there is actually, I would submit, a publicity of some sort of private facts in the form of that phone call. And there is at least the potential that that could impact Ms. Jones' character, at least to the person who views it. I think part of my issue, and part of the reason why we had the discussion earlier about whether there is any evidence of character here, is that there's no evidence of any damages, and there's no evidence that this impacted her character. But there's certainly evidence that it was published to a stranger, and you can understand how that might invoke character, at least the way that this stranger now may think about this other person.
Yeah, how so?
Well, if I'm making a video call, hopefully this never happens, but if I'm incarcerated and I place a video call and I see a stranger on the phone who's partially nude, I'm going to think certain things. Who is that? Why are they being shown in that way? I may make certain conclusions about that person. It has the potential, and again, this is where we go back to this being such a crazy fact pattern, but it has at least the potential to impact someone's character.
But you would interpret that to mean that in some way, her being showed nude was a negative character flaw of hers? Is it that what you're saying?
I don't think I would think that, but I think my point is
but isn't that the logical extension of what your point here is?
What I'm trying to say is that I think that the publicity element here potentially could invoke character. Again, my issue is
I understand you're saying it could, but I'm trying to get to how it does, how it could possibly do so.
We know that there are no damages that have been proven here, so I don't know that I can say that about this particular case. It's just an observation I had from listening to the argument and trying to understand this distinction about character, and are we talking about character in general? Are we talking about it specifically with an invasion of privacy claim? But I would...
Go ahead, we'll let you,
I would...
time is almost up, but we'll let you
Okay,
wrap up.
just very quickly, one thing we haven't mentioned is the why. Why should this type of claim not survive? I submit to you it's the same reason why a defamation type claim should not survive. The damages are so unbelievably speculative and personal and peculiar to the person whose privacy was violated. And I submit to you that's why the restatement says what it says. That's why 25102 makes that distinction for character. Finally, on public policy, the cases that counsel mentioned, the hypotheticals that she mentioned, all include some evidence of physical injury. Those claims would be brought. This is the extraordinary situation, as the Court of Appeals said, where there's no awareness that anything happened and there's no injury. We have, in this case, not just hypothetically, we have criminal charges brought against the people.
I did tell you to wrap up.
I'm sorry.
Yeah.
We would ask you to please reverse the Court of Appeals and to conclude that this claim does not survive the death.
Thank you. Thank you, counsel. Interesting case, excellent arguments. We appreciate your good preparation. Case will be submitted. We stand adjourned.